Great. Well, thank you very much. Thank you first to the Center for Sustainable Investment for the invitation. It's my pleasure to be here. Thanks to Lisa in particular for organizing this event. Thanks to all of you for braving the elements to get here. And to those joining by webcast, welcome. So the topic for the day is transparency and investor-state arbitration. And it's been a fairly hot topic, actually. Over the last year or so, there have been a number of interesting developments in the field. First, on April 1st, 2014, the UNCITRAL's rules on transparency in treaty-based investor-state arbitration came into effect. And that was the culmination of a multi-year process and negotiation at UNCITRAL, which produced these rules, which now apply to UNCITRAL arbitration under investment treaties concluded on or after April 1st, 2014, unless the parties opt out of them. The second big development was over the summer, UNCITRAL completed its work on the text of a multilateral convention to apply the transparency rules to existing treaties, meaning those that have come into force before April 1st, 2014. And that convention, the Transparency Convention, which is also known as the Mauritius Convention, it'll be open for signature in Mauritius on March 17th, 2015. So a lot's been going on in the area. Now, who should care about these developments? Well, first and foremost, governments, I think. Governments have two important decisions to make. The first is immediate. So to the extent a government is negotiating an investment treaty now, and which calls for UNCITRAL arbitration, it needs to decide whether or not it wants the transparency rules to apply because they have presumptive application going forward with respect to new treaties. So there needs to be a decision on whether to include transparency or expressly exclude those rules. Second, governments may want to consider whether to sign on to the Mauritius Convention in March. And what that would do, it would allow for the transparency rules to be applied to all the existing treaties in force before April 1st, 2014. So two fairly significant decisions for governments. In addition, arbitrators and practitioners, I'm sure there are many among us, should become familiar with the transparency rules if you're involved in investor-state arbitration, because increasingly they are becoming used in these proceedings. To date, there's been some transparent arbitration under NAFTA and CAFTA, but as we look ahead at the types of agreements that are being concluded, the Trans-Pacific Partnership, TTIP, these are all most likely going to include some form of transparency standards. So it's good to get familiar with them now. And thirdly, I think public interest groups like your group obviously have an interest in these developments, and as they know, now is probably the time to be pressing governments to adopt transparency standards as part of their investment treaty policy. Now, given the importance and the timeliness of the issue, I wanted to talk about four things today. The first thing I wanted to do is go through very briefly the policy rationale for transparency in investor-state arbitration, talk a little bit about developments in the United States and at ICSID, the International Center for the Settlement of Investment Disputes. Then I wanted to talk about the debate over transparency at UNCITRAL. It was a difficult negotiation at times, as many of us know who were involved. And it produced a very divided outcome, which we'll talk about. And then I wanted to march us through the key provisions of the transparency rules and of the Transparency Convention. And then finally, I'll just sum up by talking a bit about the things I think that states, investors, and public interest groups may want to be thinking about in the weeks and months ahead. Okay, so with that, let's begin. The nutshell explanation of the policy rationale for transparency in investor-state arbitration. And I believe, Lisa, you've given out some materials that discuss this in more depth, but in my view, the argument really boils down to 3 points. The first is that the public has an interest in knowing when official government conduct is being challenged in an investor-state proceeding, As you know, oftentimes investor-state arbitration involves challenges to government measures that are designed to protect or promote public welfare objectives. So these may be measures relating to health and safety, labor, and the environment. And any challenge to these measures arguably is maybe viewed as a threat to the public interest who benefits from this kind of regulation. And so they should know about what's going on in these proceedings. The second point is that the public has an interest in knowing about when a government's management and use of national resources is at issue, which it often is in investor-state arbitration cases. A lot of these cases involve public sector services, access to water, electricity, oil and gas, telecommunications, and so the outcome in these proceedings could affect the public's access to these national resources, and so the argument goes they should know what's going on in the proceedings. And then finally, the public has an interest in knowing when a government faces claims that could adversely affect the public purse. As we know, investor-state arbitration awards can be very large. You may remember when the CME award came out against the Czech Republic. It was, I think, in excess of $300 million, and the figure that everyone was throwing around was that it was larger than the annual national health budget of the Czech Republic. So obviously, these awards can have a big impact on the public purse and in turn on the public, and so they should know about their existence and the nature of the proceedings. So there are good reasons, I think, these are good reasons for making investor-state arbitration transparent. And in many ways, the nature of investor-state arbitration is unique, which distinguishes it from commercial arbitration, which traditionally has been confidential. Now, as you may know, investor-state arbitration was not originally designed to be transparent, and much of it still isn't. And in the United States, this caused a bit of a problem, particularly when public interest groups found out that NAFTA Chapter 11 tribunals were rendering decisions in what they called, under secret conditions. And this caused quite an outcry in the United States, which culminated in March 2001, when the New York Times published a rather scathing article about the conditions under which NAFTA Chapter 11 cases were being decided. And the headline read, "NAFTA's powerful little secret, obscure tribunals settle disputes but go too far, critics say." And then the article reported that their meetings are secret, their members are generally unknown, the decisions they reach need not be fully disclosed. So this article it was sort of the watershed moment, I guess, in the United States, and it had quite an impact. And so fairly soon after, the U.S. government changed its policy toward investor-state arbitration. And so what it did was the following. First, in 2001, a few months after the article, the United States issued its NAFTA interpretation. It interpreted the NAFTA such that it did not impose any general condition of confidentiality on the parties, and the NAFTA parties pledged to conduct investor-state arbitration under transparent conditions. Later, there would be a statement on amicus curiae participation, which laid out the conditions for outside parties to participate in NAFTA Chapter 11 proceedings. Then, in 2002, the U.S. Congress enacted the Trade Promotion Authority Act, and in that act, the Congress established negotiating objectives for U.S. free trade agreements, which included transparent investor-state arbitration, namely open hearings, publication of key documents, and access for amicus submissions. And then finally, in 2004, the United States revised its model bilateral investment treaty, and it included more detailed provisions on transparency in investor-state arbitration, covering many of the same topics, and it sort of brought into line the U.S. FTA practice in this area. So those are all the developments, and these developments caught on in other forums, and in 2006, ICSID would make certain reforms as well, revisions to its rules, which were not quite as Significant, perhaps, is the United States revisions, but the ICSID rules were revised to include the possibility of amicus submissions. That was in Rule 37. And Rule 48 was revised to strengthen the obligation of the center, the Secretariat of ICSID, to publish excerpts of the legal reasoning of tribunal awards. So that was a very brief discussion about developments in the U.S. and at ICSID, but this movement was taking hold in certain parts of the world. But this takes us to the next topic I wanted to talk about, and that's the consideration of transparency at UNCITRAL, because here the issue was a bit more controversial. And just by way of background, the issue came up while UNCITRAL was revising its 1976 arbitration rules. And in the course of that revision, I think a number of delegations recognized that the UNCITRAL arbitration rules are used frequently in investor state arbitration, and so perhaps they should be revised to address the unique circumstances of those types of proceedings. Now this was recognized a bit late in the process, and so it was decided to finish work on the arbitration rules and then take up the issue of transparency in a separate work stream, which began in 2010. Now, as this work stream began, it became immediately apparent that many UNCITRAL delegations were very deeply divided on the form and the content of any transparency standards. And it gave rise to a very rigorous debate. And two camps emerged from that debate. The first was the opt-out camp. And the opt-out camp was more comfortable with transparency. Some of the countries that had, NAFTA countries that had participated in transparent proceedings and had designed that system were in this camp. They were comfortable with transparency. They wanted to make the transparency rules mandatory and wanted to integrate them into the UNCITRAL arbitration rules so that when UNCITRAL arbitration was an option under an investment treaty, you would immediately pull in the transparency rules as well. And the parties could opt out if they desired, but they had to do that expressly, otherwise the rules would apply. And the idea was to promote transparency as broadly as possible. Now, within that opt-out camp, there was even a faction that wanted to apply the transparency rules to all the existing treaties. There were some close to 3,000 treaties that had references to the UNCITRAL arbitration rules. They wanted to have the transparency rules apply retrospectively under a theory of dynamic interpretation. So that would mean that even if 20 or 30 years ago the parties had agreed to allow UNCITRAL arbitration under a treaty, the understanding would be that they wanted the most recent version of the rules, and that would then include the transparency rules. So that was the opt-out camp. And there was another camp, the opt-in camp, which was a bit more cautious about transparency. Maybe they didn't have the same experiences as some other delegations, and they preferred that any standards of transparency would be voluntary. They'd be in a freestanding instrument that the parties, either disputing parties or state parties negotiating treaties, would have to mutually agree to in order for the rules to apply. And this is where it gets the name. You would opt in to the application of the rules. And their concerns were basically that if you assume that every reference to the UNCITRAL arbitration rules meant to include the transparency rules, that the negotiating parties, which may not have had that in mind at the time, might not, there may be a lack of notice and consent, which concern them. So these were the two camps, and the debate was quite divided, and in the end there was a necessary compromise that was met, which basically divided application of the transparency rules temporally. So as you can see on the screen here, and this agreement is reflected in Article 1 of the transparency rules as well. If you look at Article 1, Paragraph 1, you see that the UNCITRAL rules on transparency apply in UNCITRAL arbitration pursuant to treaties concluded on or after April 1st, 2014. So the transparency rules are part of the UNCITRAL rules, but they apply only going forward as of April 1. So that's a significant limitation on the scope of application. Now, the rules also say in Article 1, Paragraph 2, that they don't apply going back. So, of course, it allows the parties to any arbitration to agree mutually to use them, but otherwise it says that there must be some sort of instrument, maybe a multilateral convention, like the Transparency Convention, that by which state parties would consent to use of the transparency rules in arbitrations under treaties concluded before April 1st, 2014. So that's sort of the lay of the land in terms of the application. And with that, we can start into a discussion of the rules themselves, unless there are any questions. Nope. Okay. So let's start with Article 2. So Article 2 provides the transparency standards at the time of the commencement of the arbitral proceedings. And that is when the notice of arbitration is initially filed. And the basic rule here is that at that stage, just some basic information about the claim has to be made publicly available. And this information includes the name of the disputing parties, the economic sector involved, and the treaty under which the claim is made. So very basic stuff. And the purpose here is to put the general public on notice that a claim has been filed and to give some very basic details about the nature of that claim so that the public can begin to monitor and follow this case and perhaps organize itself to participate perhaps in the proceedings at some point. And we'll talk more about how that could be done. Article 2 did cause some debate at UNCITRAL because there was, the opt-out camp was very used to the NAFTA practice of publishing the entire notice of arbitration at the commencement of the proceedings. This was not new, and it didn't cause any difficulties, at least for those countries. But a number of delegations were concerned that releasing that much information at an early stage of the proceedings could backfire in some ways, particularly if the parties were trying to negotiate a settlement. It may be unhelpful to have the full notice available. It may harden the positions of the parties and make it difficult to reach a compromise. Some were even concerned that having a notice of arbitration out there with a massive claimed amount could even unsettle certain governments. So the compromise was to just put out some basic information about the claim, and this is very consistent to the way ICSID announces the registration of claims. So this was basically the compromise. I will note, though, there's nothing in the rules, in the transparency rules or in the UNCITRAL arbitration rules that prevents an investor or even a respondent to make the notice of arbitration public at that point. So that can be done. Now, Article 3 is really the heart of the transparency rules, and it requires publication of the key documents in the proceedings, subject to certain exceptions, which we'll talk about in a second. But really, the entire system of transparent arbitration, hinges on the prompt publication of key litigation documents. The idea is to get out that information to the public, and not only so that they can become educated, but that they can even participate in the proceedings. And so for that, the information has to be made public, but it also has to be made public promptly. So this is basically what Article 3 does. Now, there was some concern during the negotiation of the rule about the costs and the burdens of making all of these documents available, some of which could be quite voluminous. And so there are graduated obligations throughout Article 3, which tries to balance the public interest against any burden to the parties. So if you look at Article 3.1, it requires prompt and automatic application of the primary pleadings, the submissions of the parties. and submissions of any third parties like amicus or non-disputing state parties. And if there's any table of exhibits that was prepared in the course of litigation, that also has to be published so people can know what's behind the pleadings. Hearing transcripts have to be made public promptly and automatically, as do the decisions, orders, and awards of the tribunal. Second, this is under Article 3, Paragraph 2, expert reports and witness statements must be made publicly available, but only upon request by an outside person. So it's not something that has to be done automatically, but if an outside party requests it, the tribunal will see that the documents are made publicly available. Third, under Paragraph 3, Article 3, Paragraph 3, exhibits, which can be quite voluminous, and any other documents not covered in the first two paragraphs may be made publicly available, either on the tribunal's own initiative or upon request by a person after consultation with the parties and under conditions determined by the tribunal. And this is really where the balance between public interest and burden comes in. So if it's very difficult and burdensome to publish all exhibits, which can be quite significant, in a case the tribunal can order certain special arrangements to be made, one of which is actually mentioned in the rules, and that is to set up the documents for access at a specified site, so like a reading room. And there's also provisions that would require that the requesting party in that circumstance pay the cost of making those documents available to them in that form. So that is Article 3. Now, Article 4 covers third-person submissions, also sometimes known as amicus submissions. And these are submissions by people who are not parties to the proceedings and are also not the non-disputing state party, so the other state that has negotiated the investment treaty. And amicus submissions are obviously quite important, an important element of transparency, because they are the vehicle through which an informed public can add a meaningful perspective to the investor-state arbitration process. However, during the negotiations of the rule, many delegations raised concerns about the manageability and cost of dealing with a potential flood of amicus submissions. And so accordingly, Article 4 creates an opportunity. It's not an absolute right, but an opportunity for third persons to file written submissions regarding a matter within the scope of the dispute if the submission meets certain criteria, such that a request for leave to file the submission should be granted by the tribunal. And in essence, just to sort of summarize them, it's a fairly lengthy provision, but in essence, there are three criteria which are based primarily on NAFTA and ICSID practice. The first is that the third person who wants to make the submission has to demonstrate essentially that he or she is not trying to unduly influence the outcome of the proceedings. So Article 4 requires disclosure of direct or indirect connections with a party or any significant financing of a submission by a party. Secondly, the third person has to demonstrate that he or she has a legitimate interest in the proceedings and can assist the tribunal in determining factual and legal issues in a useful way that the disputing parties themselves cannot. And third, the third person's submission may not disrupt or unduly burden the proceedings or prejudice a disputing party. So Article 5. Article 5 establishes the right of a non-disputing state party, so the other party to the investment treaty, who's not the respondent, to file submissions on issues of treaty interpretation. So usually that would mean the meaning of the treaty that's at issue in the arbitration. And this is obviously a very important provision from the perspective of a state, because it ensures that both parties that have negotiated the treaty, not just the respondent party, but both parties have an opportunity to express their views as to the meaning of the treaty that they both concluded. So that's the one thing that Article 5 does. The second paragraph of Article 5 allows for non-disputing state parties to file amicus submissions on basically the same terms as any other person would. And the idea behind that was, why would you treat non-disputing state parties any differently than you would the general public? And so they are allowed access as well. The article raised some controversy at UNCITRAL because a lot of delegations were concerned that these mechanisms would be used by the non-disputing state party, which was the state of the investor, to intervene on behalf of the investor. And they actually saw it as some form of disguised diplomatic protection, where the states of the investor would come in and try to tip the scale in favor of their national. In fact, the practice has proven otherwise, at least under NAFTA and CAFTA. Typically, the non-disputing state parties come in on the side of the respondent because they share the same interests as the respondent in interpreting the treaty in a certain way. But nonetheless, to appease concerns, there is an additional factor that's put into Article 5, Paragraph 2, that says that tribunals must also take into consideration the need to avoid submissions which would support the claim of the investor in a manner tantamount to diplomatic protection. There were also similar concerns about cost, burden, and so you have, as you have in Article 4, a provision that says that the tribunal must ensure that any submission doesn't disrupt or unduly burden the proceedings or unfairly prejudice any disputing party. Now, Article 6. Article 6 states the broad rule that the hearings must be open. They must be public. This is mandatory. And it's a very important provision because a lot of new information, important information, can come out at a hearing. Refined legal arguments and factual arguments may be presented. Information is adduced during a witness examination and expert examination. So it's important to have the hearings open. But Article 6 was a very difficult provision to negotiate at UNCITRAL because there were significant concerns about how that process would be managed in a way that didn't present security risks or logistical challenges. And on the issue of security, a lot of governments, delegations, particularly those who weren't familiar with open hearings, were concerned that the release of information, some of which might be embarrassing to a government, in real time could present real security challenges. And they also, I think, had a hard time getting their head around the logistics of open hearings. How would you invite the public into, this proceeding? And so you'll see in Article 6 there are provisions that provide assurances on both of these issues. Article 6 contains provisions that direct the tribunal to hold parts of the hearing in private when it's necessary to protect confidential information or the integrity of the arbitral process. And it also highlights that in making the logistical arrangements for an open hearing, the tribunal may organize attendance through video links, so you don't have to actually bring the public into the proceedings. You can have a video link to a viewing room, or you can even have a webcast if conditions call for it. And it's also the rules also say that where necessary for logistical reasons, the tribunal can hold all or part of the hearing in private. So that was the way to manage concerns about Article 6. Now, Article 7 contains a number of exceptions to transparency. And Article 7 really, I think, reflects the reality that in some cases the need to protect sensitive information is going to outweigh the benefits of making that information publicly available. And so there's a series of exceptions that call for non-disclosure of information, and it was really these exceptions that made the whole package palatable, at least to many of the skeptics of transparency. And so I'll just quickly go through them so we know them. The first, confidential business information, doesn't have to be disclosed. It's not a defined term, but it obviously covers things like trade secrets or any other sensitive business information. Information that is protected from disclosure under the treaty. So an investment treaty itself may have provisions on non-disclosure, and those would have to be adhered to. Information about the respondent state that is protected under the respondent state's laws. So here we're talking about state secrets laws, things like that. Information that is protected under any law or rules determined by the tribunal to be applicable to the disclosure of such information. So here we're talking about attorney-client privilege information, deliberative privileged information. All of that is protected. Information, the disclosure of which would impede law enforcement or which a state considers contrary to its essential security interests. I think that's fairly self-explanatory. And information, the disclosure of which would jeopardize the integrity of the arbitral process, including by hampering the collection or production of evidence, leading to the intimidation of witnesses, counsel, or arbitrators. I think that's also self-explanatory. So those are the exceptions. And because there are so many exceptions and there's a need to protect information under certain circumstances, Article 7 designates the arbitral tribunal as the body that has to oversee the logistical and procedural arrangements to protect information. And this may include overseeing a redaction process, which would generally take place between the parties, and if there were any disputes as to what information should or shouldn't be redacted, they would go to the tribunal, and the tribunal would decide. The tribunal would also obviously handle the logistics at a hearing for protecting information, and this is sometimes done if you have a live feed to a reading room or to a viewing room. You would cut the feed during the confidential parts of the proceeding. Article 7 contains a fail-safe mechanism. So if there, for any person, for any party, whether a disputing party or a third person or a non-disputing state party, if they submit information to the tribunal and they're unhappy with the designation that they get, that it has to be disclosed, they can then withdraw all or parts of the submission. That's the ultimate fail-safe. Now, Article 8. So I think implicit in all that I've been saying is that there's some entity out there that's going to be publishing this information. And that entity is designated in Article 8. It is the Transparency Repository, which is administered by the United Nations, and more specifically, UNCITRAL, the UN Commission on International Trade Law. They now have a transparency registry, and they're ready to publish any information that they get. Now, they have two different functions at different stages. As mentioned, before constitution of the tribunal, they're going to be receiving the notice of arbitration from the parties. They're not going to publish the whole notice, but they're going to cull the basic information from that notice and then post that on the website. And then once the tribunal is constituted, they're going to start receiving actual documents, redacted documents, and they're going to post them on the website. So basically, the UNCITRAL in this capacity serves a purely administrative function and makes very few value judgments as to what should or shouldn't be made publicly available. That's all done in the proceedings overseen by the tribunal. Okay, so I just wanted to, that ends the brief race through the transparency rules, which gets us back to our scope diagram here. And just to show you what we've done, so the transparency rules that we just talked about are only going to be applicable presumptively going forward on or after April 1st, 2014. And that sets up a significant problem because there are thousands of investment treaties with references to UNCITRAL arbitration that have been concluded before April 1st, which are outside the scope of the transparency rules. So we need another instrument to apply the rules retrospectively, and that instrument is the Transparency Convention, which we'll talk about next. So, any questions up until this point? Okay, great. So, the Transparency Convention. So the idea behind the convention was basically to give those governments that wanted to apply the transparency rules to existing treaties the opportunity to do so to the fullest extent possible. So if you look at the scope provisions of the convention in Articles 1 and 2, they're very broad. So if you were to just sign on to the convention, you would cover the entire field. you can sign on two bases. Well, if you just sign on, you get all this. You get the full package, the gold standard, and that is that you agree to reciprocal application of the rules. So if you are a respondent in a proceeding and the investor, the state of the investor is also a signatory to the convention and has taken no reservations, then you apply the rules. Or you can make a unilateral offer to arbitrate on transparent terms, basically to the world. And finally, you would agree to apply the most recent version of the transparency rules in existence. And one day, perhaps they'll be revised, and you would automatically be upgraded to that newest version of the rules. Now, because for various reasons, governments may not want the full package at this point, the Transparency Convention includes a number of reservations. And so here the idea is you could sort of pick a la carte the level of transparency that you wanted to commit to, with the hope that you would increasingly become more committed to transparency. So basically, a number of reservations can be taken. A party can carve out the following. They can carve out specific investment treaties. So if there's a particular treaty that they don't want transparent arbitration under, they can carve it out. So, and it could be for good reasons. For example, the United States has a number of existing treaties, pre-April 1 treaties, that have very strong transparency standards built into them. And so they may decide that they want to carve out those treaties so that their standards will apply, and there won't be confusion between application of both. Also, you know, I mean, there are other reasons to carve it out. You may just be a bit skittish about transparency and want to take baby steps, and you can carve out certain treaties that you might believe would have a lot of traffic under them. You can also take a reservation for specific sets of arbitration rules or procedures. You can't carve out the UNCITRAL arbitration rules, that comes with the package, but you could carve out ICSID arbitration or ICC arbitration as you wish. And this reservation is respondent specific. So if you're in a proceeding and you're the respondent and you've carved out ICSID arbitration rules and you're in ICSID arbitration and the investor's saying let's apply transparency, the convention wouldn't apply. However, if it's the investor state that has carved out, taken the carved out ICSID arbitration, but the respondent hasn't, then you would apply the transparency rules. There's also the ability not to make the unilateral offer to the world. You can take a reservation for that as well. And you can also take a reservation to avoid application of any future revisions of the transparency rules. However, you can only do this within a 6-month window after adoption of those rules. And so finally, just to reemphasize, it's an a la carte system, so you can take multiple reservations at various times and remove reservations piecemeal as you like. The idea is to make it as easy as possible for states to increase their commitments to transparency. Now, Article 4 is on the timing of the effect of reservations. And so here you'll see that the convention generally favors commitments to transparency and disfavors decreasing commitments to transparency. And so the starting point for any government is when they sign on to the convention. Whatever reservations they take are in effect when that convention enters into force with respect to them. However, if you were to withdraw a reservation at any time after the conventions come into force, it would take immediate effect. However, if you want to take an additional reservation after the convention has entered into force with respect to that government, there's a 12-month delay. And the idea here, I think, was to avoid gaming of the system. So if a government sees it's about to be hit with an investor-state arbitration, it can immediately take a reservation to block transparency in that proceeding. And then, of course, there was the special rule for future revisions of the transparency rules. You have 6 months to decide whether or not to take a reservation to opt out of the newly revised rules, and that would take effect immediately within that 6-month period. In Article 5, we have the rule on the application of reservations and withdrawals of reservations to pending cases. The general rule is that neither the conventions entering into force or the effect of reservations or withdrawal of reservations will affect ongoing proceedings. So if there's an investor-state arbitration going, it will continue, either with or without transparency, depending on which reservations the party has taken. And here again, I think the idea is to avoid gaming of the system. So even if you would take a reservation blocking, say, an ICSID arbitration, and that arbitration lasts 3 years, and your reservation takes effect in 12 months, it still wouldn't affect that proceeding. That proceeding would remain under transparent conditions. How we're doing. Okay, very quickly, I'm going to start picking up the pace. Regional economic integration organizations can join the convention so long as they're comprised of states that are party to investment treaties, so the European Union can sign on to the convention. Very briefly, it takes 3 governments to sign on and ratify and deposit their instruments of ratification for the convention to come into force. We can skip the others. And so with all that in mind, I just wanted to spend a minute considering what various players might want to think about in the weeks and months ahead as they consider their policy towards transparency. And I think, as I mentioned in the beginning, I think the biggest considerations now are, fall to the governments in the context of deciding whether they want to incorporate transparency into their future treaties and their past existing treaties. I think at this point it's probably clear from my comments that I think generally transparency can be good for the system. By opening up the process, you're going to make the players more accountable. You're going to make the decisions more public. You're going to get a more probably consistent and fair process. And it's going to probably be viewed as more legitimate by the outside public if they actually know what's going on. So I think generally there are benefits to transparency. Now, all states are not created equal, and so some are at different levels of development, and they have different capacities. And so this bullet on readiness for transparency is just meant to highlight that while transparency may be good generally, I think states should think very carefully about whether they're ready for it, whether they're really willing and ready to make official positions publicly available. And I don't say this because it's a bad thing, but because it takes a lot of care and discipline in formulating opinions, and I think states want to do that carefully for 2 reasons. One, official positions by governments, particularly if you have a pleading with a position and it's signed by the Minister of Justice, they may be evidence of state practice, of customary international law, and that can be very important if you're trying to define certain customary international law standards of investment protection, like the minimum standard of treatment. I know that the U.S. government goes to great pains to very carefully craft those positions because they know they're going to go out. They're going to be public. They're going to go out into the world, and they're going to form part of customary international law. The second thing I think states should think about is the fact that with the proliferation of investor-state arbitration, states are increasingly repeat players in the process, and so I think a state wants to make sure that the positions they take in one investor-state arbitration, particularly if they're made public, don't come back to haunt them in another proceeding. And so, particularly when states outsource a lot of their representation to outside counsel, there's a risk, I think, that there may be more of a focus on the narrow interests of winning the claim than perhaps the long-term interests of the government in developing and maintaining an investment treaty policy. So those are 2 things that I think states should think about. As to costs, well, yes, transparency does increase costs. You're going to have administrative costs from whatever center you use, and you're going to have more lawyer time and more arbitrator time redacting documents and reviewing amicus submissions. And so it does increase costs, but But I think generally the benefits outweigh those costs, and they're not insurmountable. And finally, security. Well, I think security is an issue, but at the same time, I think as we discussed today, the transparency rules contain a lot of provisions which protect practitioners and arbitrators and whoever else is involved in a proceeding from any dangers that may occur at the hearing or otherwise. So I would say that is a consideration, but it's one that can be managed under the rules. Now, very briefly, investor considerations. Well, I think they benefit in very similar ways by transparency. Every investor is going to have to make its own choice about whether they want a private proceeding or a public proceeding. And here I'm talking about when they have the choice. Obviously, if it's mandated by a convention, they won't. But for now, mostly investors can choose whether or not to agree mutually to the transparency rules or accept maybe an offer, a unilateral offer under the convention if those are made in March. But every case is different. I mean, I can see why investors would be attracted to private proceedings. It would depend on the nature of the case. There may be very sensitive information that even despite the exceptions, they're worried about making publicly available. They may simply not want their dirty laundry aired, particularly if they have a long-term relationship or are trying to maintain a long-term relationship with the government, and so they may prefer private proceedings. At the same time, if an investor has a strong case and they've exercised the nuclear option of investor-state arbitration, they may very well want to get it all out there. And we've seen that many times, particularly by some large oil companies when they've got big claims against various sovereigns. It's all over their internet, their websites, and they're publishing all the pleadings. Finally, security. I think similar issues can be addressed from the investor's perspective. And finally, I just think investors should be wary about disclosures that they may be required to make pursuant to domestic law, like SEC disclosures and such. They just want to make sure that the decisions that are made by the arbitral tribunal are consistent with those requirements, and so they're going to want to make it known in that process of determining what is disclosed and what is not, their domestic law disclosure requirements. And then finally, and maybe I'll turn to Lisa because you know this better than me, but my guess is that public interest groups are pleased with developments on the transparency front. I think they will benefit as well from transparency, particularly by being able to participate as amicus in proceedings. And I think now probably the goal is to build support for the adoption of these rules, as broadly as possible. So with that, it's exactly 1 o'clock. I thank you very much for your attention, and happy to answer any questions.
Thanks so much. Sophie, do you have any questions?
Yeah, so I would have a very simple question actually. Do you think that it's really going to change anything if we consider that now it's the arbitrator who has to balance between the principle of transparency versus the exceptions? And thinking of two concrete examples, are the rules now going to change if we're in the case where there's a question about a document, can the document be made public, and the two parties consider that no, and will the arbitrator resist that and really go and say, I think it might be really important, can an arbitrator, is that possible?
Well, that was the idea of making the exceptions very clear. You're absolutely right. The goal was to ensure that the parties don't collude to avoid transparency. So that's why the obligations are clearly defined and the exceptions are clearly defined, and the tribunal is bound to follow them. So, and there are probably don't have enough time to get into all of it, but there are some provisions in the in Article 1 that prevent certain abuses that might lead to the problem you're talking about. But I think it is designed. It was thought through very carefully to address that very situation.
I do a lot of work for a country that has no PITs, and I've looked at the transparency rules, and you really can't say, if you're not in a treaty context, that you want to be governed by the transparency rules, because they're so full of treaty references that I don't think you can't just take them and apply them without a whole lot of confusion and possibly not getting to the desired result. Have you seen any effort to translate those rules into rules of general principles that could be referred to, so you don't have to? Everything I do is in the form of concession agreements, in which the arbitration rules are spelled out in a fairly lengthy arbitration section.
That's really interesting. Well, you're right. I mean, these are designed for use in treaty-based investor-state arbitration, and they would probably require some revision, I think, to work in say, a commercial arbitration. I certainly don't think it's impossible. I think the basic framework
These are
is that.
investor-state arbitrations. They just wouldn't become.
Well, it certainly wouldn't.
In the context of a VIT.
Right. Well, that's the question. Would you want to use them in commercial arbitration? You certainly could. You'd have to revise them, I think, here and there. But yeah, no, you're right. I mean, it would take some doing to adapt them. But I think, I mean, the idea was to have, in the rules, I don't have them right here, but there are two versions. There's the part that's embedded in the UNCITRAL rules. You've got the rules, the UNCITRAL arbitration rules, and the transparency rules together, and then you've got the freestanding principles. And the idea was that even outside, maybe the context of the convention or whatever, those rules would be used in arbitration. I think it's another step to say that they, could be used in commercial arbitration, and then that would have to be thought through carefully. But I don't think it's impossible with some revision.
Any other questions? All right, well, I think in the interest of time, we'll wrap it. I have a quick question. Do you have a feeling of how many states will be signing on to the convention when it opens for signature?
Well, it's a great question. I think there's going to be an immediate rush by a handful of staunch proponents, the ones that led the charge at UNCITRAL, to sign on to the convention in March or shortly thereafter. I think honestly, after that, it's going to be more of a trickle. I think a lot will depend on what the European Union member states decide. If you could get all of them to join, that would be significant. And I think it's going to depend a lot on whether some, I guess we'll call them South countries, join, because a lot of sort of the North-North, there aren't a lot of North-North investment treaties, and so, with the exception of the NAFTA. You're not going to get a huge coverage that way. I think just having, for example, the United States and Canada sign on would be useful because, most but not all NAFTA Chapter 11 proceedings are transparent. It's still done by mutual agreement. So, that would be something. We just have to hope that.
Will the United States sign on?
I would imagine that they would be one of the first.
I was wondering too if home states could require their investors or could do something to encourage their investors to also offer unilaterally to arbitrate under the rules. Do you see home states thinking about that, like the U.S. saying, when our investors use investor-state arbitration, please offer to arbitrate under the transparency rules?
Well, states can certainly do that, and it has been the U.S. practice to do that in NAFTA proceedings. So certainly you don't need to sign on to the convention and make the unilateral offer. You could make that offer domestically just as easily. I think there's something about having it in the convention. You're locked in. Yeah. It takes 12 months to get out of it, so it's more of a significant commitment. But certainly at the domestic level, you could be offering this up to investors as well.
So I think with that, we'll close. But yeah, thank you.
Thank you very much.
Yeah, thanks.
Good luck, everyone.